Okay, looks like we're just at the hour. Why don't we get started? My name is Joseph Caniglio, and I'm the Director of Antitrust Innovation Policy, as well as the Schumpeter Project on Competition Policy here at the Information Technology Innovation Foundation. On behalf of ITIF, I want to welcome you all to our panel. The DOJ v. Google Saga continues. What's at stake in the search remedies trial? By way of a short introduction, following Judge Mehta's decision in the DTC finding that Google monopolized the general search market through a series of agreements with browsers, Android OEMs, and wireless carriers to make Google the default search engine, a remedies trial is set to begin later this month that will determine the remedies that will be imposed upon Google, which in the DOJ's proposal range from eliminating the agreements found to be anti-competitive, measures to designed to restore lost competition, and other restrictions on any competitive behavior such as self-preferencing, including through a breakup involving Chrome as well as potentially Android. So to discuss this truly landmark trial, I'm honored to have with me a very distinguished panel of experts, and I'm going to take the liberty of being brief with introductions so we can jump right into things. First, Diana Moss, Vice President and Director of Competition Policy at the Progressive Policy Institute. Prior to joining PPI, Diana was the longtime president of the American Antitrust Institute, leading and I think really the first antitrust reform-focused think tank in Washington. She also serves as an economist at the Federal Energy Regulatory Commission. Diana has spoken and published widely in all areas of antitrust and competition policy, and is also an adjunct faculty at the Department of Economics in the University of Colorado at Boulder. A pleasure to have you join us, Diana. Second, Herb Hovenkamp, the James G. Dinan University professor at the University of Pennsylvania Carey Law School. It is, of course, not really possible to do justice to Herb's contribution to antitrust law, so I will only say that Herb is quite simply the leading scholar of U.S. antitrust law. In the words of the New York Times, the dean of antitrust, has a vast corpus, which includes hundreds of articles and over 1,000 citations by federal courts, including dozens from the Supreme Court itself. He is, of course, co-author of the magisterial Arita Hovenkamp Antitrust Treatise. Herb, it's a privilege to have you with us. Third, Adam Kovacevic, founder and CEO of the Chamber of Progress. Adam has had a long career in the tech industry, including as head of North America and APAC government relations for Lime, as well as leading Google's U.S. policy strategy and external affairs team for a number of years. He's also served as board member of a number of leading technology policy organizations, not least of which has included ITIF. Glad to have you with us again, Adam. Finally, we have Ben Nagin, partner at Sidley Austin and co-head of the firm's Global Antitrust Group, with whom, in full disclosure, I had the pleasure of working for in a prior life. Ben is the leading antitrust litigator and listed in the best lawyers in America as a super lawyer for antitrust litigation. He's handled dozens of high-profile antitrust cases, including a successful defense of a financial services firm that recently got him American Lawyers Litigator of the Week. Ben, thank you for taking the time to be with us. So Herb, I want to start with you and again, jump right into things. And before we get into the specifics of the Google case, discuss sort of what antitrust remedies mean more generally, which I think is an area that perhaps has been perennially under-discussed and perhaps even a bit underappreciated, even among the antitrust community, especially when we think about the context of a civil monopolization case of this magnitude, which of course doesn't come around all the time. So what should the purpose of antitrust remedies be at a high level? Courts talk about things like rescinding illegal conduct, undoing ill-gotten gains, addressing other behavior, or even creating competition, restoring competition. How should we think about this?
Thank you. First of all, the statute is remarkably general, remarkably non-specific about what it orders. It authorizes the federal courts to, quote, prevent and restrain antitrust violations. It does not speak in particular about breakups or divestitures. It clearly authorizes injunctive relief. It's an equity provision. This court is operating, of course, under the control of previous Supreme Court decisions, but most particularly against the Microsoft decision, where Microsoft stated the goals, and I'm just going to quote briefly here, is unfetter a market from anti-competitive conduct, terminate the illegal monopoly, deny to the defendant the fruits of its statutory violation, and ensure that there remain no practices likely to result in monopolization in the future. As Diana Moss observed in a report that I'm sure we're going to be discussing a little bit later, simplicity is our friend here, and complexity is our enemy, particularly in fast-moving, innovative markets like this one. And furthermore, we should not underestimate the effectiveness of simple injunctions. They can accomplish a lot, and the more uncertainty there is in the market, and the faster things move, the better, the stronger the case for an injunction becomes. Microsoft in particular was particularly concerned about going beyond an injunction to some kind of structural relief, held repeatedly that the courts needed to be much more cautious before they award structural relief, and also established what is really kind of a two-stage causation requirement, which means if you can prove the violation, you're more or less, presumptively at least, entitled to an injunction. However, if you want to go beyond that, if you want to obtain some kind of breakup, some kind of structural relief, then you need to be able to show more, which is that the defendant's dominant position is largely a consequence of anti-competitive conduct and not of its own superior investment efficiency, and so on. And then finally, just one sentence on the numerous possibilities in between a simple injunction and a breakup are intermediate remedies, data sharing, and so on. All of them fall within the name of the statute. That doesn't necessarily mean they are wise remedies, but they are certainly within the realm of contemplation, provided that they make the market work better. Thank you.
Herb, thank you very much for starting us off there. I think that's very, very helpful. So Ben, I want to turn to you now and maybe drill down a little bit on the legal standards. You know, Herb mentioned the Microsoft case, some of the causation analysis. But think about it from a litigator's perspective. I mean, what are sort of the key issues that Google, the Department of Justice, is going to be working through? And in particular, maybe the question of from a legal perspective, how tailored, how much of a relation does there need to be between the actual remedies themselves and the conduct that actually is being challenged in the case? What does the law look like on that?
Yeah, thanks, Joe. And let me just say, it's really an honor to be on the panel with really this distinguished and thoughtful group. So I'm thanks very much for this. I mean, look, you know, Herb went through what the DC Circuit said in Microsoft, and the last point I think is the most troubling in a sense in terms of grappling with, you know, what the court can and should do. That is, ensure that there remain no practices likely to result in monopolization in the future. And that is, you know, that feels like potentially language that one could grasp onto as a broad mandate. And then, you know, equally broad and I think vague is the prevent and restrain language, which people could read into as much as they could read into, say, what's on the side of a police cruiser to serve and protect. People may have different views of that. But just to drill down, Joe, you know, when you're looking at conduct that's been deemed anti-competitive, you don't really have too much trouble, or a court shouldn't, with enjoining that conduct, assuming it has no or little pro-competitive positive import. That's the easy causation. The more difficult is when you get into something that get into conduct that's really not been found to be anti-competitive. And so in terms of self-preferencing, those words don't appear in the decision. Self-preferencing, those words don't appear in the judge's decision. So then to bring into a remedy that takes direct aim at self-preferencing, I think it's going to be problematic. The judge is really going to have to grapple with that in terms of the causal connection. And I think, you know, in looking, you know, for signals for the Supreme Court, there was a huge blinking one in Alston where, you know, the court said, you know, judges have to be mindful of limitations. They're generalists. We are lawyers, and to understand sort of what the court called intricate business relationships, which, by the way, move at lightning speed in the tech industry. The court said judges have to remain aware that markets are often more effective than the heavy hand of judicial power when it comes to enhancing consumer welfare. And so when reviewing complex business arrangements, particularly ones that have not been the subject of the decision, courts have to be wary about invitations to, quote, set sail on a sea of doubt. That is not coming from academic antitrust thinkers. That's not coming from DC advocacy groups or think tanks. That's coming from the Supreme Court. And so I think when the court starts to dig in a little bit, those admonitions from the Supreme Court and elsewhere will be there.
Ben, thank you for that. I think that tees it up perfectly. Diana, I want to sort of turn to you. And, obviously, this remedy, like Microsoft remedies are going to be reviewed under the public interest. And I know you just came out with a great paper over at PPI, really discussing a lot of these key issues, right? Thinking about how this remedy is going to improve consumer welfare and also the administrability issue, right? And avoid turning courts into central planners, very much, I think, along the lines of sort of concerns Ben was raising. So what's your take on remedies generally in that regard?
Well, thanks, Joe, and an honor to be on this panel with very esteemed colleagues on a really timely and important topic. So as an economist, I'll come at it from that perspective, and really the way we think about remedies in the economic frame is deterrence. There's this thing called optimal deterrence theory, and it's been deployed heavily, especially on the cartel side. We have a big body of literature on global international cartels and fines and penalties and settlements and that kind of thing. So, but I think you can talk about deterrence of future bad conduct or future harmful mergers. You can talk about that, in the context of cases like Google or leading merger cases where the agencies have obtained remedies. And to deter bad conduct, obviously, you have to restore competition to the market in some way, shape, or form. And that typically takes one of three forms or multiple forms, as we see in Google. There's simply injunctive relief, which is just stop doing what you're doing, stop the bad conduct. And then, of course, what economists really focus on is, are the structural remedies that we see. Divestitures, obviously, are the leading and preferred structural remedy, but also conduct remedies. All of that taken together is designed. If the design of a remedy is really the focus of the thinking, is to restore competition to the market. Which will then, of course, discourage or de-incentivize bad conduct and serve to deter. And so I think that's really the frame. And the role of economics, especially in conduct and structural remedies, is focused on how do you reduce these incentives to exercise market power. Do you use divestiture, for example, to reduce the size of a company in a horizontal play? Or do you spin off assets in a vertical play to reduce incentives to foreclose competition and ice out new entry? And so, we think about a reduction of incentives to exercise market power really is the focus of disconnecting the current market structure and current market dynamics from what we would like to see in terms of more competition, more effective competitive process. So I think that's what's really at issue here. I think especially what's at issue is the use of conduct remedies, which are, proscriptions and prescriptions on the types of conduct that a firm can engage in moving forward. And we'll talk more about this later, obviously, but, the remedy in the Google search case really consists of just we have a structural component, obviously, in the divestiture of Chrome and potentially even Android, but the conduct remedies are on steroids, and I call it in the paper a form of quasi-regulation. I'm a former federal regulator, and I lived and breathed conduct remedies for 7 years at the Federal Energy Regulatory Commission. But quasi-regulation, aka very complex conduct remedies, are much less effective in terms of reducing those incentives to exercise market power. In fact, they don't reduce them at all. They just simply restrain how the firm can behave, and that's where the rubber meets the road.
Diana, thank you. Adam, I want to turn over to you next. I mean, we got from her sort of the high level view of what antitrust is about here. Ben drilled down on some of the legal issues, Diana on the economic side. But I want to sort of get even more concrete in a way and talk about sort of the real world business implications of one of these major antitrust remedies. I know Diana's paper mentioned some of the history here as well. I mean, we don't have a ton of history. We do have some examples to think about. And even in Google's case, right, we had some remedial decisions in Europe. So how should we think about this from sort of the industry business level? Adam, I think you're on mute. You may still be on mute. I think.
Well, if you're concerned if the business side is not getting enough air in the remedies discussion, this is suggestive of that.
Right. Well, I know we want to get into that because obviously there are a number of companies that have expressed interest in the remedy, obviously beyond just Google. So why don't we wait till Adam comes back and we'll jump into the specific remedies that are being considered. So we talked about the difference between behavioral and structural remedies, which are obviously key for thinking about this. But I think there's another sort of way to break it down too, which again gets to the purpose of the remedies. And I think in the DOJ's proposal, they kind of think about it this way too, right? Namely, distinguishing between, Adam, do we have you? We can't hear you. Bummer. We'll wait till you get that figured out. But so Ben, I want to start with you here. Thinking about maybe the first group of remedies, namely a sort of bunch of remedies that are, whether it's structural or behavioral in nature, the idea is to prevent anti-competitive conduct, right? So what do we make of those remedies in the proposal? How sound are those from a legal perspective? And again, here we're talking about preventing the agreements that were found to be anti-competitive, other potential anti-competitive agreements that weren't involved in the case, and then also the structural remedies, which are designed to prevent self-preferencing, and then even additional conduct remedies to prevent self-preferencing. So what do we make of that sort of bucket of remedies?
Let me just sort of talk about it from the practitioner's perspective and how I, as a litigator, think about approaching it. And one thing that that's really at the fore of my mind is, what's the judge's mindset? How is the judge approaching this? It is one thing to listen, carefully and thoroughly to the evidence in front of the court and then make a decision on the law. It is quite another thing to impose, remedies that go beyond what was in front of the court. And I think that's going to give the court quite a bit of pause. Those of you who have either litigated cases or read enough cases will have heard the following from a court. I don't want to decide something that's not in front of me. I don't want to issue an advisory opinion. That's not part of this case. That's collateral to this case. That is something that judges give a tremendous amount of thought to. They want to decide what's in front of them, what's been in front of them, and what's at issue in the case. And that's going to, Joe, extend to the remedies as well. A number of the remedies are not tied specifically to the proof in the case and the claims in the case and what the judge found. Self-preferencing is an example of that. Another example is, sharing data. The proposed remedy would require Google to share all kinds of data. And I think, the court is going to look at the law, which will easily permit the court to enjoin something that was established to be anti-competitive in the claims of the case and based on the evidence of the case. But where the relief, where there starts to be daylight and substantial daylight between the relief that's requested and what was proven, that will give the court quite a bit of pause. And for me as a litigator, that's what I would sort of grasp onto, because judges really want to decide what's in front of them. In fact, we all have seen the confirmation hearings for Supreme Court justices, and the thing, whether they're on the left or the right or somewhere in between, they will say we decide what's in front of us. We're umpires. We call balls and strikes. If something's in front of us, we'll decide it one way or the other. And I think that's going to continue over in a powerful way to the remedies hearing. And I'm sure Google is banking on that too.
That's very helpful, but I really do think it is helpful to distinguish between, again, those sort of remedies about preventing any competitive conduct that were actually found to be anti-competitive in the case, and that those remedies that are designed to prevent other anti-competitive conduct that was not found to be anti-competitive in the case. And, Diana, I want to turn to you because I think those structural remedies are really designed to prevent self-preferencing. So assuming, let's say that the DOJ can do that and they have some ability to go after self-preferencing, that does, of course, mean that divestiture is the way to do it, right? So what do you think about maybe that in particular, and maybe some examples from history about how we should expect these divestitures to work out? I know it's something you discuss in your paper.
Yeah, so the way I'm thinking about these remedies, and as we know, there are many of them, and in the paper we do not discuss every single remedy, but rather the remedies that we think are most likely to impact consumers at the end of the day under a fulsome interpretation of the consumer welfare standards. So I'm thinking about them in two ways. One is remedies that are designed to eliminate incentives to foreclose competition, and foreclosure of competition occurs in a number of different ways. Self-preferencing is a major theory in this particular case. So remedies that delink or reduce or substantially depress incentives to limit or stifle competition. The second bucket of remedies that I think about are the remedies that are designed then to open up that market or facilitate the development and the blossoming of competition in the market for online search. So that's kind of how I'm bucketing them out. In the first category, eliminating or reducing these incentives to exercise market power, that's where the divestiture comes in. And I think, from an economic standpoint, we can just view that as a traditional vertical relationship between the online search platform and Chrome. So, the browser market is a complementary market, much like the cloud market is complementary, much like the device market is complementary in these big, digital ecosystems, which are a very unique kind of business model. So if you delink the vertical integration or sever that, then traditionally the way we look at vertical mergers, AT&T, Time Warner, Comcast, NBCU, Live Nation, Ticketmaster, that is designed to eliminate, weaken or eliminate that incentive altogether. And it can be a very effective way to do that. It's not the only way to do that. The second bucket of remedies, of course, are designed to sort of open up the market to competition. And those then break down into, well, stop doing, stop the bad conduct, no more default contracts for default placement of the search engine with very powerful players in complementary markets. No revenue sharing that would create incentives to prefer Google as an online search engine. So there's the revenue sharing and the default. The rest of them, however, are really designed to as DOJ borrows the language from Microsoft, in this case, to pry open the markets to competition. So that's where we see control of market entry by the technical committee deciding who's a qualified competitor and who can get into the market. All the data sharing of the search index, the ads data, the user side data. The proposal tries very hard to bring the consumer into the mix through the choice screen recommendations, and then this prior notification requirement that DOJ be able to sort of get the final word on all future acquisitions in the space. So I think that's the way it breaks down. I guess the biggest, the point I would make, and we make this in the paper, is this is a tremendous amount of complexity. It's a mixture of structural remedies, of injunctive relief, and conduct remedies. And arguably, not any single one of these, but possibly different combinations of these remedies could actually do the trick, could serve to stop the bad incentives and to open up the markets to competition. The question is whether this sort of Rube Goldberg machine that the proposed final judgment, the revised proposed final judgment creates, is actually going to have unintended consequences for consumers in sort of overreaching or overshooting the mark. And we got to keep our eye on the consumer, right? If the goal is to correct, address an illegal violation, restore competition to a market, consumers have to benefit from that. That there has to be demonstrable evidence that they will benefit from that. And the more complex the remedy, the more difficult I think that is.
Diana, thank you. Adam, I think we have you back, and I'm sure you're
Can you hear me okay?
on all these issues. We can hear you loud and clear.
Okay, good. Sorry about that.
No, that's okay. So turn it over to you. Obviously want to get your thoughts maybe generally on the remedies question. What's sort of business industry perspective, Google's perspective, but then also, of course, feel free to apply it on some of these specific remedies. And I think, there's a lot of ways to think about it, Diana, divide them up, but also, just maybe thinking about it in the sense of sort of the thou shalt not, right? Thou shalt not commit any competitive conduct bucket, right? Starting with those. And then we'll get into, of course, the other ones, the more prescriptive remedies about trying to create competition. But please.
Sure. I mean, I think the thing to me about this case has always been that the case itself is actually quite narrow in terms of focusing on Google's search distribution agreements. But the way that the case began under Trump in the waning days of the Trump administration was Bill Barr kind of casting about for a Google case and, thinking about bringing like an anti-self-preferencing case, and they rejected that. And then they kind of landed on this, but they never really cared too much, in my view, about what case they brought. They wanted to bring a Google case. Okay, then the case is prosecuted by the Biden DOJ, and they win. And now you have the remedies stage. And what I think the Biden DOJ did in the remedies stage is they kind of created an open house, really, for any competitor, anybody who had any complaint about Google to come forward. They kind of opened their doors and said, okay, if you have any issue. And the remedies they put forward reflected that, because they went far beyond, as we've been talking about, just narrowly focused on the deals in question, to things like divesting Chrome and requiring that, that Google do a public education campaign about alternative search engines, which is just kind of crazy to me. Things like, overseeing kind of how websites opt out of AI training. Again, none of this had anything to do with the actual case being brought. And so I sort of called it remedy spaghetti by the Biden DOJ. Let's throw a bunch of stuff. There was really kind of costless on their part, because, what's the consequence for prying the Overton window of remedies as wide as possible? And you could almost say, okay, well, maybe their strategy is to have so many remedies, and there's so much complexity that if the judge rejects kind of the far off remedies and just focuses on the search distribution related remedies, then he feels like he's being conservative. But even those have real consequences. So to your point about the business, I think that, what the Biden DOJ landed on with these remedies really kind of represented a pretty broad scale attempt to kind of re-engineer Google's business. And as Diana noted, I think the courts are going to be pretty wary of that, given the Microsoft precedent.
Adam, thank you. Herb, I want to make sure you can weigh in on this as well. I know you had a great article in the New York Times some months ago specifically discussing the structural issue.
Yeah, I've got a couple of thoughts right now. Number one is, I don't think the term self-preferencing has helped antitrust policy one bit. It's created this impression that profit maximization is a bad thing. Well, our market system is based on an assumption of profit maximization. We expect firms to self-preference. What we really need to address is anti-competitive self-preferencing, which really means anti-competitive exclusion of rival technologies. We've got quite a bit of antitrust law that does that. The law of exclusive dealing, the law of time arrangements, whatever law we have on refusal to deal already addresses it. So I think it's misguided of the Justice Department to put so much weight on this rhetorically loaded topic of self-preferencing. Secondly, I'm reluctant to break up complements unless there's a very clear case to be made for anti-competitive foreclosure. I mean, ordinarily, complementary products work together better than when they're not operated together. They're frequently cheaper. They're designed to work well together. So, most of the things you think of as happening when two complements held by a single firm are separated are not very good ones. The one problem is they do create foreclosure issues. And I think it's incumbent upon the government in that case to show that foreclosure is a realistic threat here. And with Chrome, I frankly don't see it. At least the case has not been made to me yet that divesting Chrome is going to change the landscape here very much. I'd like to see more evidence of that, but right now I simply don't see it.
Herb, I appreciate that. I think that's really a great way to sort of end this topic and then move on to the next one, which is just this idea that, even in Microsoft, right, you had some idea of self-referencing technical tying leveraging, right, where Microsoft was in theory using its operating system to benefit its browser, right? So maybe there was some sort of foreclosure incentive there, of course, that a structural remedy, vertical divestiture might solve. But of course, here, as many of you noted, that's not the case we have here. There is no allegation that sort of Chrome is being used to benefit search. And I think that's key. So Diana, turning over to you for the next part. Again, I tried to divide these remedies into the two buckets. The second bucket now being the sort of thou shalt prescriptive remedies trying to restore and create competition. Folks have mentioned the data sharing, syndication, the other issues in that area. And of course, in your paper, you talk about the risk of de facto regulation and a lot of the costs that could have. I mean, I think there's certainly a view that preventing anti-competitive conduct, sort of the first bucket, well, at least that's pretty administrable. We can do that. But this other bucket of remedies, I think, raises a lot of those issues. So could you lead us off there?
Sure. So this bucket of remedies that are really designed to sort of restore competition in the market, pry it open, whatever words you want to use, do very much resemble a very regulatory style remedy. Yeah, almost what you might get out of a sector regulator under sort of an open access regime. When I was at FERC in the 90s, that's what we did. We did open access, and it was very interesting, but very difficult process. Particularly in terms of, well, what does this do? What will this regime do to change incentives, for example, for the networks, and in this case, in Google, the platform, the search platform, to innovate, to continue to innovate the platform. Having a standalone search platform, obviously with no ownership interests in complementary markets, just from a pure economic theory standpoint, could be expected to reduce incentives to innovate. Because of that delinking of vertical integration. So then the question becomes, well, how do you work around that? How do you maintain incentives to innovate? So I think what makes this even more of a sticky problem in online search is the fact that the digital business ecosystems exhibit really unique and funky economic characteristics, right? We have huge economies of scope and scale and in data and in cloud computing. There are information asymmetries in terms of how users interact with the digitals. They often do not accurately express their preferences for privacy. They behave in ways that violate their own preferences. So it's these very characteristics, I think, that kind of put some of these proposed remedies on steroids. So, just to give you a concrete example, opening up the forced sharing of Google data, of Google's data, the search index, the user side data, even the ads data, will now open up that data to many, many more market participants. Data is the currency of a digital business ecosystem. So the more you can get your hands on data, the more enriched that data can be through the use of machine learning and AI, the more valuable it is. So because it is the currency and the value proposition is to monetize on data through advertising and algorithmic suggestions, the rivals who get access to this data could have very strong incentives not to protect data privacy because it is so valuable and it is the currency. That is a major concern for consumers. If we open up this platform and turn it into sort of a quasi-regulatory entity under these complex conduct remedies, then the very nature of the digital ecosystems and their characteristics could actually lead to less data privacy and less data security. And if you put that on top of what are now very likely to be weaker incentives to innovate, that the flow through to the consumer is not looking very good. It's looking like consumers may be on the short end of the stick. And certainly one of the concerns is that the DOJ's proposal doesn't really talk about the consumer. It's mentioned, the consumer, the word actually appears a couple times. We see something about a passing reference to consumer choice as a result of the remedy. We don't see anything on the effect on innovation and the benefits that consumers get from incentives to innovate. We don't see anything on quality, and that's where the data security and privacy issues come in. I also think, just in closing, that whenever you have a big conduct remedy like this, and we've seen this in Live Nation Ticketmaster, and we've seen it in other big cases, the efficacy of the remedy is entirely dependent on smaller market participants coming to the fore to report violations and discrepancies and how they are affected by that. So, these very unique elements, I think, do not work together particularly well in this context.
Diana, thank you. I mean, I think that really does nail it. I mean, some of these remedies, these forward-looking remedies, I think, as the DOJ calls them in their proposal, is very, very much quasi-regulation, and it's going to deal with the costs of that, both in restricting innovation and other effects. But Ben, I want to turn to you next. I wonder if we're sort of putting the cart before the horse here, right? Diana's laid out the negative effects these sorts of remedies can have, but does the DOJ even have the right to go so far on some of this stuff? I mean, how much leeway does the law give them to really try and engage in this sort of de facto regulation and create competition, again, in a way that really doesn't seem to have a lot to do with the actual conduct that was found to be anti-competitive?
Yeah, I mean, it really sort of goes back to where we started a little bit in the admonition of the Supreme Court in Alston about courts giving deference to business decisions and not looking for the ideal, platonic ideal or regulatory ideal of where the DOJ antitrust division or a particular judge thinks the market should be, but really looking, this is obviously one of the learnings from Microsoft or a number of the Microsoft cases. Is there a causal connection between the anti-competitive conduct and the dominant position in the market? And that's really where the debate, I think, should be and needs to be under the law. And I think that's the key legal framework. It's not a regulatory mandate for the judge or for the DOJ. It's not, this kind of case does not provide for a remedy to penalize conduct. That's very important. Sort of penalization is not part of the mandate here, and the causal nexus really is something that provides some legal barriers. And I think that is what the court will come back to again and again. What is the causal connection here? And also in the background will be the admonitions about giving deference to business. But look, there's a lot to be concerned about in a regulators type mandate here. I mean, here, interestingly, we have, and we can come to this later, but we have Apple and others coming in and vehemently trying to express their own views about what the proposed remedies would do to them, and in the anti-competitive effects that they think the proposed remedies will have. So it's a very interesting dynamic here.
Ben, thank you for that. Herb, want to turn it over to you next, and then I do think we want to get into open it up a bit, some of these broader issues that are very real, both on the industry and also a lot of the other cases that are going on. But Herb, first on these sorts of remedies, I mean, you mentioned the injunctions, the structural relief. That's all stuff we're very familiar with in antitrust, very much standard fare. But some of these other remedies, the data syndication, data access, the ad transparency, information to advertisers, and then again, the choice screen, that all sounds to me to be of a very different type antitrust remedy. I mean, I think the DOJ calls it in their brief that their motion, basically the syndication is almost dealing with Google accumulating a tremendous amount of data over the years, such that this is almost a disgorgement type of remedy. How much precedent is there in sort of the antitrust law for, again, going beyond the antitrust standard fare and then bringing in these other types of justifications for antitrust remedies?
Well, first of all, Microsoft restricts the range quite a bit. I mean, if you take the Microsoft decision the way I think we need to take it, it really does require some kind of proven causal relationship between the defendant's monopoly and the anti-competitive conduct. I don't think that rules out something like a choice screen, because I tell you, the one thing I like about choice screens is they throw the decision and the right to the consumer. Whatever you might want to say about them, they throw the final decision making to the consumer. So a properly designed choice screen can go a long ways. On these other sharing remedies, I see them as perhaps having some value as transitional, but really not very much more than that. That is to say, you don't increase airline competition by increasing the number of travel agents. And here, you don't really increase structural competition by giving a whole bunch of people access to a common database. That's not a competitive remedy. That's a regulatory remedy. I can see it working for a few years to give firms a chance to get a leg up in the industry. I mean, we did that with the AT&T breakup. We permitted a lot of firms to interconnect with long distance service. There were tiny firms operating out of their garages that provided long distance service in the early years after the breakup. But those are not structural solutions. And I think what you really want to go for here is a structural solution if you think structure is the fundamental problem. I'm not convinced of that yet. I hold out a lot of hope that a well-tailored injunction can open the road, an injunction that it would have to prohibit this payments for self-preferencing. It would have to put a limit on any kind of explicitly exclusionary conduct, and then let rivals develop as best they can. And the one thing we know from Microsoft is that if you eliminated those exclusionary agreements, and the injunctions in the Microsoft case did a fair amount of that, the market would open itself up to new rivals. I mean, one answer to that is, okay, Google came in right afterwards and that took care of it. But the thing is, these are markets in which it's very, very difficult to predict what's going to happen in the future. They are fast moving. People will take the opportunities where they lie. And so I'm a much bigger fan here of narrowly structured relief that goes after that conduct that was actually found to be anti-competitive.
Herb, I think it's great to bring up Microsoft again in that regard, in the sense that, of course, the DOJ is very complimentary of the Microsoft remedy in the Apple case, which, of course, did not involve a breakup, and digital competition flourished. So I think that's certainly a good lesson here as to maybe why a breakup might not be necessary in the Google case. But why don't we open it up now? I see we got about 15 minutes left. And again, I want to invite our viewers to post questions, submit those via Slido. So we might get to those. But why don't we just start with, again, the broader implications of this remedy? I mean, we mentioned Apple, and there are other browser providers too that really depend on these agreements. So what might be sort of some of the unintended consequences of this remedy, both on the search space and also potentially in other markets, like I mentioned, the browser market? Adam, could you maybe start us off with that?
Sure. So, I mean, as you say, you're right. I think that, there's all these downstream business effects. Apple's wanted to intervene. Mozilla is very concerned. Anthropic is very concerned. And I think that that's what's always been strange about this case, is that it's been targeting Google, but it affects all these other players in the industry. And I don't know that the DOJ has sort of sufficiently paid attention to that. I also think, Diana talked about her personal experience working at FERC. I don't want to have a FERC for search engines, right? I don't think that's a good step towards search engine innovation. And, I was struck by a point that Heard made, which is like, about future-oriented competition here. I think in many ways, some of these remedies are crafted for a world in which Google's main competition is Bing and DuckDuckGo. But I have to think that its main competition going forward is ChatGPT and Perplexity and Claude from Anthropic, right? Which the remedy says nothing about it, and frankly probably shouldn't. I think that kind of competition is good. And I was also struck, Herb talked about ballot screens. I think what's happened in Europe with respect to some of their regulation, both company-specific regulation of Google or antitrust actions on Google, as well as some of their Digital Markets Act regulation, provide cautionary tales, right? Because with the Digital Markets Act, it requires broad-scale data portability. So it requires that Google does share search engine data with some of its competitors. But even Europe, which is not really known for this, recognized that there have to be some limitations on that because of property rights and privacy. And so the way that Europe forced data sharing under the DMA is more constrained. The ballot screen initiative, I think, sort of points out like the challenge here of kind of the moving goalposts. What happened in Europe when Europe required Google to do ballot screens on Android devices is that Google provided it. They said, okay, when you have an Android device, you can use a bunch of different search engines, including Bing and DuckDuckGo. And the market shares didn't change that much. Consumer behavior didn't change that much. People mostly continued to prefer Google. And DuckDuckGo went in to complain to the Europeans that this was a faulty remedy because it didn't change market shares. And that, I think, points out sort of one of the fundamental problems you have when the DOJ opened its doors to competitors and said, what remedies do you want us to see? What they're basically saying is, these remedies aren't going to work unless they lift up your business against Google. But is that what remedies should be designed for? Or, should they be designed for giving people choice? I think you're going to see if the DOJ wins this and if they have remedies that are enforced over, a period of time by technical committee as they, want, then I think what you're going to have is competitors spending the next 10 years saying, no, these remedies are insufficient unless they force consumers to change their behavior. But what if consumers are happy with Google?
Adam, thank you for that. Anybody else want to weigh in on this? There's a lot of places to go, Diana. I think I saw you nodding your head. Please.
Yeah. I just want to make a couple of points here. I think in understanding why what the DOJ is proposing is so very complex, we have to understand what the perfect remedy would really be. And it's a remedy that DOJ could not get and would not get. And that would be to take Google and break it up into a set of smaller search platforms, much like breaking up AT&T in 1982 in that consent decree. The reason why that remedy was not obtainable is, of course, because there are incredibly powerful network effects in search, which create, strong movement towards tipping the market to a single technology or a single provider. But think about it. That would have been a one and done kind of remedy. Let's have 5 little Google search engines and rebrand them or rename them. And then we're good to go. We'll have a competitive market. That absolutely would not have been effective in restoring competition. So that's why we have this kind of complexity with a structural remedy and then this quasi-regulatory regulation of a standalone search platform. So that's number one. Number two, I think this case is extremely unusual in the amount of market pushback from market participants, and others have mentioned this already. I think it's really unusual to have this level of pushback about how the remedies will spill over to affecting the business models and the operation of participants in complementary markets, right? Device manufacturers, browsers, applications, the whole thing. And part of the problem here is that there are such a diversity of these market participants that are potentially impacted by the remedies. And they are not only diverse in what they do, but in their size. Some are larger, some are smaller. that actually complicates the remedy as well. So if you superimpose all of this on these very unique digital business ecosystems with all of their unique economics and a very dynamic, rapid rate of growth, I think the remedy would risk sort of freezing the market for a 10-year period, with impacts on quality, innovation, pricing of devices in complementary markets, for example. And so I am not finding that nuance or recognition of that in DOJ's proposal. It's almost like a traditional approach to a manufacturing industry. And look, I'm not saying no remedy is needed. Absolutely, there's been a violation, a remedy is warranted. The question is, what kind of remedy are we going to get, and how's that going to affect consumers?
Thank you, Diana. Ben, Herb, looking to you, weigh in on this, but also maybe a different sense of the broader implications of this case, not just on the search and related industries, but on the law. Obviously, we've got a lot of other big monopolization cases going on right now, and we like to cite to Microsoft. That case is 25 years old. Is this really potentially another big bellwether case that's going to have a lot of important implications as to what a good antitrust remedy should look like? Herb, Ben, any thoughts?
Yeah, I think one big difference between this case and some of the other platform cases is the availability of significant product differentiation. That's clearly true with social network sites. They're very different from each other. So we're always going to have an equilibrium of, Facebook, X, LinkedIn, and others. We can debate about which ones are in the market and not in the market. But the fact is, it's a pretty competitive arrangement. And cell phones, we've got two major operating systems competing with each other. We have never been as successful the market has never been as successful at producing significant differentiation in search. I think of DuckDuckGo, that originally came in the market with cloaked searching. Everybody else copied it right away. And so we never got very much differentiation there. I think as long as differentiation is not on the table, that is, as long as all these firms face very similar demand curves, there's not going to be an equilibrium that has multiple search engines. Now, I think AI could make a difference here. GPT, Perplexity, and these other firms, they're doing very different things with search. And one of the things I think that remains to be seen, and this makes me cautious about remedies, is will we be able to see a future evolution of search in which we have a variety of search engines in the same way we have a variety of social network sites? And that would facilitate an equilibrium situation with multiple firms. We haven't had it yet. And the remedies that the government is proposing, frankly, I don't think gets us one step closer to getting there. That's something that's going to rely on market developments, not on a court injunction.
Thank you, Herb. Well, of course, regarding market developments, obviously, Judge Mehta did not think AI was very relevant here. And again, that's a very debatable point in my view. But of course, Biden DOJ certainly did think it was, which is why they originally had a lot of those provisions in there preventing AI acquisitions, which the Trump administration has since moved away from.
But that's a terrible solution to try to keep Google out of AI. No, you want as many players as possible to get in there with their own unique solutions, and that's the way competition should be working in this market.
Exactly. Well, I would also note too, I mean, one of the things about the Microsoft case is that really was a case about protecting innovation, right? Microsoft was going to stifle the internet, and that was the next big wave. Of course, none of these current cases, at least by my read, including the Google case, have anything to do with the companies sort of stifling the next generation of competition vis-a-vis AI. It's all very backward looking. I think it's an important difference. But Ben, your thoughts on these issues?
Yeah, I mean, again, from the litigator's perspective, one thing to keep in mind is that this upcoming remedies trial may have some new evidence, right? In a world where things are moving very quickly, Google's going to have the opportunity, and DOJ as well, to put in new evidence as to what has happened and what is likely to happen going forward. And so the battle was fought anew, but to the extent that AI is, continuing to take off and continuing to play a role in expected and unexpected ways, that all will be at issue. And I think will really drive home the difficulty of, big structural remedies untethered to the sort of the backward facing record at the liability case, which already has started to be some time ago, given how quickly things move, especially now. I sort of joke to my transactional colleagues that I'm a sort of a litigator of history. I'm a historian who fights about history, and then there's going to be a winner or a loser about history. But when you get to a remedies trial, you're no longer a litigator of history. You become sort of a futurist, and that's a very different role altogether, and one where I think the enforcers and the judge just have to tread a lot more carefully. And I think the law is consistent with that too.
Thank you, Ben. So being a futurist for respect to this panel, we've got about 5 minutes left, and I want to make sure that everybody has a chance to maybe give a 1 minute sort of concluding thought takeaway for our viewers. We've discussed so much, but Adam, maybe start with you on that.
No, I'm just struck by, we've talked a lot about the Microsoft case and how the Microsoft case ought to constrain the remedies here to be pretty narrow. But I'd suggest that I think this was a deliberate choice by the Biden DOJ, Jonathan Cantor, to kind of swing for the fences. Because if they, again, throw all this remedy spaghetti at the wall, and the judge ends up accepting some of the far out remedies, and that ends up being upheld on appeal years from now, then they've all of a sudden they've kind of overturned or expanded the Microsoft precedent. And I think there are people who'd like to do that. I think that would be disastrous for the innovation economy, because then that would mean that, really, I think it would open the door truly to have kind of like a regulatory approach for all these companies, a huge disincentive for innovation. But I think that was the objective of some of these folks. And that's why I think to me, that's what's at issue in this remedies trial, is whether the narrowness of the Microsoft precedent will hold, or whether this is really kind of, the beginning of that falling.
Thank you, Adam. Well, that's certainly important to raise. I mean, there's a view out there that a lot of this is just negotiating, the DOJ trying to get as much as it can. So maybe there's a little bit of the art of the deal here. Diana, your concluding thoughts.
Yeah, so I would just say in conclusion that of the many factors that make this this case unique, I think the most obvious is that antitrust doesn't have a lot of experience in the digital sector, right? If we go back to the mid-90s, when the big first generation digital ecosystems were building them out, and they did that through acquisition. That's the growth model. It's not an internal organic growth model, and that's fine. There was virtually no merger enforcement. There was a lot of second requests and a lot of looking closely at acquisitions, hundreds of acquisitions from the mid-90s through today. But one challenge, I think that was Google ITA, and that was a licensing remedy. So not a lot of experience in the digitals. I think, there should be some humility from the antitrust side in realizing that there's not a deep bench here. I also think that, we look to other industries for examples of what it means to completely create a model of what an industry is going to look like for the next 10 years. And that would be the NCAA settlement. And we can that's a private case, obviously, but think about how that the injunctive relief part of that settlement has reshaped the model of college sports, completely reshaped it. And that's a whole nother panel, but it's a good analogy for potentially what is going to happen here. And then finally, the connection to the consumer under, again, a fulsome interpretation of the consumer welfare standard is absolutely essential, even in a public interest finding, right? Because that will play in significantly.
Diana, thank you. Ben, your closing thoughts.
I'd probably just, reiterate the notion of, being a litigator of history versus a futurist, and a futurist has to be a lot more careful here. And then, of course, just to say it, this decision is obviously on liability is going to go up to the DC Circuit, right? And if Microsoft is any example, this current discussion of remedies may well be moot entirely. And so that's something to keep in mind as well.
No, thank you, Ben. Certainly there are many of us, at least one of us on this panel, that has suggested there are a lot of areas where Google may be able to appeal this, and with that being myself. Herb, please take us home.
This case arises in a market in which economic growth traditionally has been 3 or 4 times as fast as the growth of the economy as a whole. Might be slowing up a little bit, but I think courts have to be extremely, extremely cautious about structural interventions in markets that seem, by all the indicia we have, to be performing very well. If you want to break up a cartel-prone, stagnant industry that's been losing ground, there's no way to go but up. But that is not this particular industry, and that tells me we need to be cautious.
Herb, thank you very much. Certainly worth thinking about not hurting the goose that laid the golden egg here. With that, I think we can end this really great discussion. I want to thank our esteemed panelists for taking the time to join us. I also want to thank everybody who tuned in. I know we had a great audience for this. And again, thank you. And please do continue to follow ITIF for watching all these many developments in tech and antitrust very closely. So thanks again, everybody. Have a great day.
Thank you.
Thank you all.